Hello, my name is Clarisa. I'm a surety claims specialist with Liberty Mutual Insurance. This video will provide a brief discussion on notary bonds. Today's agenda, we will cover and review the overview of a notary bond, the duties of a notary, the surety's liability, along with the surety's defenses and indemnity. So what is a notary bond? A notary bond is a surety bond posted to protect the interests of the public in the jurisdiction in which the notarial appointment has been issued. Each state has statutes for notarial commissions which set forth the requirement to fix application fees, specify whether notarial seals or stamps must be used, and establish state record-keeping duties and bonding requirements within the jurisdiction which issued the notarial commission. The majority of states require notaries to post a bond, and the current bond amount requirements can be located under the National Notary Association website, also referred to as NNA. Here, I've listed a short example of the state and bond requirements for your review. These are designated by the NNA. It is highly encouraged to check the current statutes in the relevant jurisdiction, which can be located on the National Notary Association website. There you'll find helpful summaries of state requirements. So now let's take a look at the duties of a notary. A notary is typically required to keep a log that records the date and time of a certain item being notarized, as well as verification of the identity of the person who also signs the logbook. This is important should there ever be a situation where a notary needs to prove that someone did in fact sign and the signature is valid. The powers of a notary are governed and regulated by statutes. An example we can look at is the Revised Uniform Law on Notarial Acts, which defines a notarial act as any act that a notary is authorized to perform. Some examples include taking an acknowledgement, administering an oath or affirmation, taking a verification upon oath or affirmation, witnessing or attesting a signature, certifying or attesting a copy. It should also be noted that other state statutes can expand the notary's public powers, such as Florida, Maine, and South Carolina, which grant notaries the authority to perform marriages. Notaries must also faithfully perform and act with care while performing the duties of office. This means a notary must take responsible precautions to assure that his or her seal will not be utilized during the course of a fraudulent transaction. Doing so will lead both the notary and the notary's surety to be held liable for any damages resulting from such negligent act. So what exactly is the surety's liability? A surety's liability and defenses will be substantive in nature and tied to establishing that the notary performed the duties properly and whether any injured party cannot establish causation between the act of the notary and any alleged damages. The notary bond, like other surety bonds, is generally only liable up to the bond penal sum. So when we would first notice whether the surety is found liable, we often have to look at a few things. First, the notary must be held liable for breach of an official or neglect of duty to the injured party. Specific acts of negligence that the surety or notary may be found liable would include the notary failing to take the required care to properly determine the identity of a forager, the notary fails to secure the signer's thumbprint, notary fails to read a certificate of acknowledgement and then certifies, on the wrong document, the signature of the person who never appeared before the notary fails to complete a certificate before signing it, the notary acknowledges his own signature, and finally, the notary breaches a statutory duty to record outstanding liens in an act of sale. It should be noted that the injured party must prove such failure was a proximate cause of loss and injury sustained by the notary's unfaithful performance in order for the bond to be called upon. So what defenses does the surety have? The surety's defenses are limited to the language contained within the bond, as the vast majority of bonds contain defeasance language such as, If the principal performs all duties, etc., the bond is void. Otherwise, it is in full force and effect. This again leads back to what we were discussing earlier in determining whether the notary properly performed its duties and whether the injured party was unable to establish causation between the act of the notary and any alleged damages. The causation issue is often the biggest one, as it has to be a pretty narrow set of circumstances for there to be damages that result specifically from the acts or omissions of a notary. We're talking about out-and-out forgery here, that the notary does not catch because it fails to go to the proper verification process on its end. Now that we've covered the surety's defenses, let's take a quick look at indemnity. The main point here is that we're likely dealing with the common law principle, which would require reimbursement of the surety's loss or losses. However, it's important to take into consideration whether the notary or principal executed an indemnity agreement, and while the indemnity agreement executed may or may not be a long or short form, the surety would likely lose other standard rights in the indemnity agreement, including the right to collateralization in connection with any claim. Therefore, common law would then come into play and hopefully provide a successful avenue for recovery. Thank you for listening, and I hope you found this presentation helpful.